series today. And today we have with us Advocate Sri Amol Nimburge sir, and he'll be speaking on Juvenile Justice Care and Protection Act. So with this lecture, we again resume our lecture series, and we hope that this lecture series, as per every series is an addition to our knowledge, same way, even the further coming lecture series will be the same. So I invite Advocate Amol Nimburge sir to kindly take charge and start with your lecture.
Thank you, ma'am.
Thank you.
I'm not sure whether I will contribute any further knowledge to this esteemed lectures of our college. But yes, I find it necessary to introduce this subject in the light of what has happened in the recent past. We are coming across with many cases or many such incidents where juveniles or child in conflict with law are found to be committing many acts which have been termed as criminal acts by our law. So that was my intention behind giving this topic for my lecture, that we need to revisit the laws which are meant for these children, and more particularly relating to the offenses committed by them. In this light, we will start with our discussion rather in regard with the Juvenile Justice Care and Protection Act 2015. As we are aware, because at some point of time we studied this enactment, whether the old enactment or the new enactment, or prior to that we have a history relating to legislation which exclusively deal with or dealt with the child-centric legislations. Before we proceed to this exclusive enactment, I will take a 2 minute for giving you an idea how the law has changed or shaped itself and become more child friendly or child centric. When we blame the British era for many things, on one hand, we have their legislations for centuries providing us guidelines or a guiding light while deciding the issues relating to law. In the same way, they have also contributed towards this particular aspect where rights relating to children have been discussed or have been taken care of. One first such enactment is of 1850, when Apprentices Act came into existence or brought into existence for those who have been found to be indulged into illegal activities, and in order to bring them into mainstream of the society, this act provided for skill development of such children for ensuring their better future. We can say that it was the first legislation which thought about providing children a better environment for their better future. We have a history drawn from various parts of the world where the laws relating to children got developed. Similarly, the international community has also played an important role in providing us the present system of law dealing with the rights of children, as well as providing them protection from exploitation, providing them better opportunities for their better future. The international community has played a very important role in safeguarding the interest of those who are found to be indulging into criminal activity, as well as those who are treated as a group of individuals meant only for exploitation. It is a sad state of affair when we talk about women and children, be that may be a developed country like America or underdeveloped country. Their state of affair was similar. Women as well as children are not recognized as first class citizens, even into the developed countries also. And this situation is much less same throughout the world. International community, though contributing towards bringing equality or providing better opportunities to the women as well as to the children, but both these classes in the society are more vulnerable or exploited by male dominant society. They are the subject of exploitation for centuries together, and even today also we are coming across with many such cases. Today only we are shocked to know that children from the age group of 8 or 10 years died because of heart attacks or issues relating to heart attacks. To some extent, the environment, the situation contribute towards their death. The competition which they face at such a tender age can be called as a factor responsible for their death. So when we talk about Juvenile Justice Care and Protection Act, we are also talking about such children. One should not misguide himself or herself by believing that this enactment only meant to provide a forum, a legal framework to address the issue of juvenile delinquency. This enactment, if we go through the provisions contained therein, you will realize that this enactment also addresses certain other important issues relating to children. Juvenile delinquency, which is very much in existence since human inception. Oh, what is meant by juvenile delinquency there? Juvenile obviously means the person who is not a major as per law, below 18 years of age. If we have to define, delinquency means a behavior which is not as per the norms of the society. which we can say that a behavior which is not acceptable to the society. So we should not mistake that this enactment is only meant for addressing the issues relating to those who are found to be indulging into illegal activities. Yes, it forms part of the enactment, but at the same time, this enactment also provides with the procedure for the purpose of adoption of children who are either orphan, who are not having parents, or there are cases where parents are, because of certain situation, are incapable of or do not want to maintain such children. Category of children which we call it as street children, who are living onto the street, they are also entitled for a better life, a good future. And when we say that every citizen, every person who born in India has equal rights regarding development, personality development, of having a good life, a part of constitution can also be related to this particular enactment, or we can say that in order to achieve those objectives provided under the constitution, this enactment is brought into existence. The question may arise in your mind, then what was the position prior to coming into existence of this first Juvenile Justice Care and Protection Act 1985? Yes, prior to that also there were enactments called as Children's Act, but mainly they were state enactments. These enactments, as we are aware, the Constitution provides authority or empowers the states to make their own law while governing the rights of children. So mostly state enacted laws were there. So in order to bring some uniformity in treatment, because there was diversity, every state has its own enactment dealing with the issues relating to definition of child or definition of child in conflict with law. And therefore, to have a uniform approach, as well as the government of India have become signatory to the human right treaty, wherein rights regarding children were discussed, and that treaty provided for bringing into existence a special enactment dealing with the rights of children, including those who have been called as juvenile delinquent. And therefore, for the first time in 1985, Juvenile Justice Care and Protection Act was brought into existence. Therefrom, Juvenile Justice Board, a special board governing, or the board has been empowered by this enactment to deal with the offenses committed by the persons who are below the age of 18 years. And the object behind bringing into existence Juvenile Justice Board is to give an informal inquiry to the acts of the person who has been brought before the Juvenile Justice Board without making that person apprehensive about the system or create fear in the mind of that person regarding the court and the system. Juvenile Justice Board, as defined under Section 4 of the Juvenile Justice Care and Protection Act 2015, is one of the important organ of this enactment. One of the basic objective of juvenile justice is diversion from the regular judicial system, which somewhat complex and which might affect the child in negative manner. And therefore, the idea is developed that children should be diverted from the formal judicial adjudicatory system and some informal mechanism should be put in place. In order to carry out that act, Juvenile Justice Board or court has been introduced, wherein 3 persons shall sit. Out of them, one shall be a judicial magistrate first class who is assisted by 2 other persons from the social background. One of them shall be a woman. If you go through the Section 4, the qualification has been given that who can be the member of Juvenile Justice Board, and they will carry out informal inquiry. The first enactment, which came into existence in 1985, has undergone a change, and in 2000, with some new changes, the law got introduced. And being a student of law, we must keep in mind that the law is evolving or it undergoes changes over a period of time, because we are aware that society changes, society transforms, so is the need for law. And when we say that, we have to keep in mind the changing scenario and our need. Some 20 years back, one would not have thought about the fraud relating to digital transaction, or we haven't heard about digital arrest kind of fraud. So keeping in mind these changing scenarios, we have to make changes in our law. And in case of Juvenile Justice Act, it has been done promptly from time to time. The government has taken the need of the hour. In 2000, new enactment was brought into existence. But the Nirbhaya case, which occurred in Delhi, and that incident had shown some lacuna, some loopholes in our system, in our law. And people were so furious as they felt that the culprit, because of his minority, is being able to get scot-free. He didn't get what he deserved. He should have been punished with death penalty, or for that matter with life imprisonment, because of his active involvement in the entire incident, causing grave and serious injuries to the vital part of that girl. That may be because of the instigation or the immaturity, but people felt that one should not escape just because of the age. And that changed into a movement, resulting into bringing into existence major changes in the Juvenile Justice Act 2015, or rather 2000, and coming into existence of 2015 enactment. If you go through the definition clause, there is introduction of certain punishment or certain offenses. And if I have to refer to it, there is introduction of offense under section definition, under section 2, clause 13. The definition provides for child in conflict with law, wherein you will find that the age is 18 years only. But while doing so, while keeping that definition intact, there is addition under the chapter of Juvenile Justice Board, providing them with power to make inquiry if a child is brought before the board as per section 14, wherein the board can carry out inquiry. And as I told you, section 2 clause 33 speaks about a new category of offense called as heinous offense. And with the changed scenario, we have to read in today's context. Include the offenses for which the minimum punishment under the IPC, which is now repealed. Now we will have to include the present penal law or any other law for the time being in force is imprisonment for 7 years or more. So that classification can be called as a result of the movement started by certain associations which felt that by taking the protection of this enactment, old enactment, the children are committing heinous offenses or serious offenses, but they have been getting lesser punishment, because one of the basic principle of criminal justice system, we can say that, or criminal law, we can say that there shall be proportionate punishment. Then only we can say that it can be useful for the society to control the offenses in the society. Otherwise, if we are having disproportionate punishment, then the same punishment will not work as deterrence, will not work as an example to the others or other like-minded people. So some associations felt that it is disproportionate, it is sometimes causing disturbance in the society as victims feel or the relatives of victims feel that they do not get justice. And therefore, the changes have been brought into existence. Was mostly was between the adoptive parents and the orphanage or adoption agency. The government has no role or very little role into it. But after 2015, this enactment, or rather prior to it, certain incidents occurred, or certain incidents brought to the notice of the central government, more particularly by the External Affairs Ministry, regarding exploitation of the children given in adoption in abroad or in foreign countries. encouraged or rather compelled the government to bring changes into the procedure laid down under this enactment regarding adoption. Though for Hindus, there is Hindu Adoption and Maintenance Act, which provides for how to carry out the adoption. But in general, this area of adoption was governed with very little or less law. And therefore, under this enactment of 2015, adoption was streamlined. Various agencies got established from national level, state level, even up to district level for the purpose of controlling or regulating the activities relating to adoption. CARA, Central Adoption and Resource Agency, got established under this enactment, which was also there on earlier occasion in 2000 enactment. So is SARA, State Adoption and Resource Agency. But now they have been given more power, effective control over the adoption homes. These adoption homes will be monitored by district level committee. District Child Welfare Committee is given with the task of visiting these adoption homes, these various facilities meant for the children, whether they are temporary, whether they are permanent. They will be inspected by the Child Welfare Committee on a regular basis, and they will report it to the state government if they found any discrepancies. Why I've said that the adoption was another crucial aspect or important area for the government to look into, because many orphanages are run in India by many agencies, whether they are government, they are private, but earlier there was no such control over them. So on many occasions, we come across with the news that they have been exploited when they are residing into that facility, whether meant for person or child in conflict with law or child in need of care and protection. These two concepts are there. Child in conflict with law, we can understand the person who has committed an offense, and therefore the JJ Act will govern him or her. But at the same time, child in need of care and protection, those children who require attention, who have been abandoned, who have left their home, who are orphan, for them, there must be certain amount of assurance from the government that they will be looked after by the government or the government agencies for that matter. These agencies were working, but there was no control over it. So on many occasions, they got exploited in those facilities, shelter home, orphanage. And because of which, the government thought it fit to bring a stricter control over it. If the government is unable to carry its own, then the government will approve certain agencies to carry out those activities. These NGOs, non-governmental organizations, charitable trusts, are allowed to run orphanages, shelter homes, for the needy children who have been abandoned, who are living on the street because of many reasons. And therefore, it was an important area to look into. So, through these agencies, now the activities, because the law laid down under JJ Act 2015 provides that every 5 year, 3 year, these agencies have to get themselves recognized. If they fail to fulfill the criteria required under the law prescribed by the government while issuing authorization, they their recognition, their authorization will be revoked. If they found any exploitation of children, those directors will be held liable or responsible for the same, and they will be punished. This is another reason why there has been changes in the JJ Act 2015. Not only that, here they are not only talking about providing punishment, providing adoption facilities, but as like the regular prisoner who is undergoing punishment for the act committed by him or her, in the same manner, these children in conflict with law are also entitled for having a regular life after completion of their stay in the facility. Then who should look after their rehabilitation? That is another important area. Because as we are aware, if in a society, if somebody is stigmatized as a criminal, then there will be very less possibility that his or her family or the relatives will receive him or her back into their company. So in such circumstances, rehabilitation has to be looked into. Similarly, in case of the children who are not in the age of adoption, they need to be given care and protection till they attain the age of 18 years or they start earning on their own. In those circumstances, they cannot be left on the mercy of their distant relatives, or they cannot be left on the destiny. The government, as I am saying again, that vested with the responsibility of taking care of the citizens of this country, the government has to make certain program for their rehabilitation that has been discussed under this enactment, rehabilitation. And rehabilitation is not only meant for those who are in conflict with law, but also those who are in need of care and protection. And when we talk about care and protection, we are aware that a child can groom or can grow, can develop in the company of loved ones, parents. If the parents are absent, then the child will not be nurtured properly. will not get those values which are necessary for ethical living. In such circumstances, there should be arrangement where the said child can get love and affection from the parents. Foster care is one of the example where children are put into a family, or child is put into a family where the elders in the family will look after, will take care of the said child, against which the family is supported by some financial support by the government for the purpose of taking care of such child. So foster care is one of the remedy, or we can say instrument, available for the government to take care of such children in need of care and protection. One has to, because if the child is in the age group of 3 years or 5 years, it can be easily adopted and can be put into an environment where he can or she can feel the love of the family. But those who have crossed that limit, there is very less possibility that those children will get adopted. So in such circumstances, a family like environment is very much necessary. I come across with an information in that regard that we have a orphanage kind of facility in Latur run by a private institution where 4 or 5 children are residing together, or 2 or 3 children are residing together, and they have been taken care by a lady like a mother. She will live with those children, she will take care of their food as well as provide them necessary love and affection. Through that support, we can see that those children are nourished from the point of view, because a person can live into the society when recognizes the value of others, the emotion of others, as well as that person can bond with the society only if he has or she has some attachment with the society. Why there is a criminal behavior in the society? Because somewhere those who are committing crime do not find themselves attached to the society, or they do not feel that they belong to the society. Kind of attachment which can be developed through the family. And so these aftercare facilities can play an important role in reducing the juvenile delinquency. Offenses committed by these individuals. If we are failing on that part, we will not see there is a change in the number of crimes committed by these individuals. If we are failing on that count, there will be no end to juvenile delinquency. We cannot claim that there shall be 100% reduction in the crime rate or crime committed by the individuals, because we have to keep in mind that we have variety of individuals around us having different thought process, different viewpoints, and absolutely we have to keep in mind, or we have to believe that even if we have a complete peace in the society, there will be some minds who will be thinking about creating trouble in the society, because we have to actually remain there. Even if centuries get passed, even if we get the tag of developed country, getting all the benefits, getting all the luxuries of life to every single individual, even then we will find that there will be criminal mind working into that society. It is the environment which plays an important role, and that environment can be developed through these after care process, that the individual, after attaining a particular age, should be put into that facility so that the person cannot get into trouble, cannot get into the criminal activities. Not only this enactment speaks about adoption or how the care in rehabilitation and social reintegration should work, or the child care institutions, children's home, place of safety are some of the examples of the same. Fit facility, fit person. The safeguards provided for adoption, whether it is inter-country or whether it is outside. For outside adoption, I must tell you here in that regard, CARA, the national level agency, has started this procedure where the prospective adoptive parents have to register themselves that they intend to adopt a child. And once such request is received, it will be analyzed, it will be verified, and prospective parents are suggested with certain facilities, adoption facilities, where they can go and check for the children available for adoption. Again, scrutiny will be carried out if they select one of the child. Scrutiny will be carried out for the purpose of ascertainment of viability of such adoption, the financial capacity of the parents. They will be interviewed by certain officers from the Child Welfare Committee, and thereafter the adoption will be approved. The adoption has to be made through an authorized adoption agency or adoption home, not from any place or from any home other than registered or verified adoption home. Another interesting provision that I come across under this enactment is in regard to abandoned child. Why I'm saying that it is an interesting, for the first time, it has been provided that those parents who are incapable of maintaining that child, those parents can surrender the child to the Child Welfare Committee. It is interesting. Section 35 of Juvenile Justice Care and Protection Act has brought into existence such a sea change, I must say, because of many reasons. The parents are not being able to maintain the child, maybe because the child is suffering from such disease which is incurable, and it is not possible for the parent to make expenses for the treatment of child, which is continuous one, which requires continuous medical attention, and because of their financial condition, they are not capable of carrying out those activities, or not been able to discharge their responsibility as a parent. In such circumstances, such parent, by making declaration under section 35, can surrender the child. Though they can make a request to the committee, even then the committee provides them with an opportunity to think over their decision of surrendering the child, and for a period of 1 month the child can live with the biological parents. That is one condition. Another condition could be if the parents are suffering from some incurable disease, some terminal illness is there to both the parents, or a single parent is there and such a parent is suffering from terminal illness. I will refer to one movie, Marathi movie. Many of you may be knowing that movie. I could not recollect the title of that movie, in which this concept has been discussed, or concept has been brought into existence, where the mother of the children, two daughters and one son, diagnosed with some terminal illness, and there is very less possibility that she will survive for more than 3 months or 6 months. So in that circumstances, she decides to give away her children to different people. So in the same way, legally, such children can be surrendered if parent is incapable of maintaining such children. Either children are having some diseases, or the parents are having some, because of which they are not being able to maintain the child or keep track of the development of the children. So that unique feature, we can say, that is provided under Juvenile Justice Act. Not only that, this enactment also talked about offenses against children. A specific chapter has been provided under this enactment act, whereby certain acts have been treated as offenses. We all know the Sheila Barse versus Union of India, 1986, SSC 632, which underlined a need to have the Children's Act, which may be enacted by Parliament, providing provisions for investigation and trial of offenses against children. This petitioner is a, and while doing one such story, she visited one of the prisons in Bombay, then Bombay, and she come across with the information, or she saw that lady prisoners were having children, who are having children are residing into that environment along with their mother. And she realized that what kind of impression the children will have, or what kind of values they will receive for the Honorable Apex Court pointing out the plight of children of women prisoners. And she followed up this subject from time to time, and that is why you can have a number of cases in her name. Similarly, Bachpan Bachao Andolan versus Union of India case where rights of children have been taken care of, as the Apex Court has issued a direction that National Legal Service Authority shall employ paralegal volunteers at police station round the clock, so that any offense in against children are dealt with, either against children offense or missing children. Similarly, under this enactment, provision has been made that names of children should not be disclosed, or identity of children should not be disclosed, whether such child is in conflict with law or in need of care and protection. And if somebody in contravenes that the provision, the punishment is provided under section 74, in the form of imprisonment for a term which may extend to 6 months, or a fine which may extend to 2 lakh rupees, or both. Not only that, if a cruelty has occurred against a child, along with the regular enactment, the provision of section 75 will come into picture. And according to the cruelty, which resulted into some incapacity, some serious injuries, the different punishments have been provided for such act under section 75. Employment of children for begging has also been made punishable as per section 76, wherein along with imprisonment, fine of 1 lakh, 5 lakh, depending upon kind of cruelty has been caused for the purpose of making the child beg, if child's hands are amputated, or any other injury has been caused resulting into any disformity to such child, then punishment is provided. 77 speaks about penalty for giving or selling intoxicating liquor or narcotic drugs to a child. And herein, punishment is in the form of rigorous imprisonment for a term which may extend to 7 years, and shall also be liable to fine which may extend up to 1 lakh rupees. Child prostitution is another issue which has become so much serious over a period of time. Or exploitation of children, whether it is sexual, physical, mental, even those issues have been addressed by this enactment, providing stricter punishment, serious punishment, and though the repealed IPC or the new Bharatiya Danda Sanhita can be brought into picture for the purpose of providing punishment along with Juvenile Justice Act. I failed to mention here one of the important aspect or feature is that if a person has been held to be capable of understanding the consequences of the heinous offense as per section 14 inquiry, then the board will refer such child to the children court. Though this concept was very much in existence in 2000 enactment also, but here a specific provision has been made that if person in the age group of 16 to 18, if found indulging into any heinous offense, such person on inquiry by the board under section 14 and after passing the order that such person is capable of understanding the consequences of the act, is referred to children court, and where a regular trial will be conducted before the children court. But again, such trial will be specific to that individual who is minor, and his trial or her trial is not mixed with the regular criminals. If there are more than criminals are there and few of them are minors, this separate procedure has been laid down. And one has to keep in mind that now, after many instances that we are coming across on a daily basis at international level, that children are being used for the purpose of creating terror, carrying out terror activities, or they have been used as shield to protect the terrorist. We come across with certain such instances where in Israel has attacked one of the children hospital, as it is their apprehension that said hospital is being used for targeting Israel or carrying out military terrorist activity against Israel. So they have been used as a shield on many occasions by the original culprits, original criminals. So we have to make changes in that regard in our law, because on many occasions innocent children become victim, become target, soft target. Now we are going into some another era, and in 20 the from 2025 the generation beta started. Those who will be born after 2025 or from 2025 onwards will be called as generation beta. So we are technologically advancing, but at the same time children are still a soft target for illegal activities. They have been used in a many ways by the parents, by the relatives, and on many occasions antisocial elements. And it will be a continuous process to make changes in our law, make amendments in our laws, that will not, or this enactment will not be a final answer to the protection of rights of children. Because as I told you in the initial my starting the topic, that women and children are being treated as second class citizen. But with the passage of time, people or the society realized the rights of the children as well as women. They both are exploited even today also because of the structure in the society. Recognizing their rights is ongoing process, and at some point or at some time we can say that our children will be free from any worries because of the initiatives taken by the government, because the recognition of their rights by the society, because the families will realize the importance of children as a future of the nation. So we will stop here. I avoided to make total reference to the provisions, as that will make uh, my lecture a boring lecture. It will be a usual lecture kind of thing. But whenever and wherever I find it appropriate, I refer to the provisions in order to point out the niceties of this enactment. Yes, there will be always a possibility of making changes or improvement in the law. So is this enactment, or we cannot say that this enactment is foolproof, because even today also, unless and until we change our mindset, we have that technology at our disposal, we cannot claim that we will be doing justice to the rights of children. So that is all from my side. Whatever little I could understand in regard with this large topic covering all the aspects of law, be that maybe human right, be that maybe constitution or general principles of law. If anyone have any questions in this regard, I will try to answer.
Any questions? Students can unmute and ask the question to sir, or any discussion if it is required. Then the points can be added. Yes, I think. Thank you
Best,
very much, sir.
Amol,
Yes, yes,
छान माहिती
yes,
दिली.
sir.
Thank you, sir. Thank you very much.
छान. हं?
Thank you, sir. Thank you.
Yes, sir, definitely. You have focused on the act in a very different perspective, that how it can be a preventive measure also to reduce the juvenile delinquency. And of course, that is one of the important aspect of the act, which focus on care and protection of the children, and which prevents them from falling into the criminal background, and just thus making prevention better than cure, that particular principle as a true principle. So on behalf of the college, sir. I really thank you for giving a good discussion, putting your point forward on this particular topic. I also thank respected Advocate Shri Bajpayee, sir, for attending and appreciating. Thank you very much, sir. It's we always remember you, and we always really follow your guidance, and which results into such good activities. Thank you very much, sir, for all your support. I thank Principal Poonam Madam also for her very support to us. Thank you all the teachers for attending, and all the dear students also for attending this session. Thank you very much. Very much. Next, we'll be meeting on the 4th of Saturday with another another lecture series from the teachers. Thank you one and all. Thank you one very much.
Thank you, ma'am.